submissions dated 28th June 2021.
Yes.
And the sixth document, my lords, is a list of authorities dated 29th June 2021, which indeed is the list of the authorities cited in the case digest and already filed in court on the 9th of June 2021. My lords, the last document we have filed on behalf of the appellant is the appellant's supplementary list and digest of authorities dated yesterday, 29th June 2021. My lords, the appeal before you is a partial appeal that arises more specifically from declarations and orders made against His Excellency the President, otherwise known as Uhuru Muigai Kenyatta, in the judgment that has been under consideration by your lordships since yesterday. My lord, the judgment in our records, or rather in our record of appeal, runs from page 555 to 563. My lords, the memorandum of appeal cites 17 grounds of appeal, which we have collapsed into 4 broad areas of argument.
Yes.
Those broad areas I would like to explain further, my lord, involve the first thematic presentation to the effect that the appellant was condemned without being given a fair hearing. Indeed, no hearing.
Yes.
The grounds of appeal, my lords, constituting that theme is paragraphs 1, or rather ground number 1, 2, 3, 4, 5, 6, 7, 8, and 9.
Yes.
The second theme, my lord, is this, that the learned judges are in their interpretation and the findings on the scope, extent, and nature of the doctrine of presidential immunity and presidential authority under the Constitution. My lord, that comprises ground number 8, 9, 12, 13, 14, 15, and 17 of the Memorandum of Appeal. Theme number 3, my lord. It was long, my lords, for the Superior Court to make a finding and a declaration that His Excellency the President had contravened Chapter 6 more specifically, Article 73(1)(a) of the Constitution of Kenya.
Yes.
My Lord, the grounds espousing that particular theme are grounds number 6, 7, 10, 11, and 12 of the Memorandum of Appeal. The final theme, my Lord, is that the learned judges are adding law and fact by proceeding to hear and determine issues, my lords, that had already been heard and determined by a competent court of concurrent jurisdiction.
Yes.
Now, my lords, I need to indicate that I will argue the first theme. My learned friend, Mr. Mohamed Nyaoga, Senior Counsel, will argue the second theme, and my learned friend, Mr. Kiragu Kimani, will argue the third and the fourth theme.
All right. But please bear in mind you have 1 hour between yourselves.
Yes, my lord. And I'm moving. We want to be very brief, my lord, seeing that all these arguments are on record. So, my lord, we have done written submissions, and in respect of whether the apparent got a fair hearing or a hearing at all is covered by our written submissions from page 6 to 12. We all know that every human being against whom allegations, my lord, are made is entitled to some minimum rights. One of these rights, my lord, is to be informed of the allegations against him or her. The second one, my lord, is to be given an opportunity to respond to those allegations. The other most important ingredient of that right is to participate in the trial. Even without going into the words of the various articles of the Constitution, I bring to the attention of the court that Articles 25, Article 50, and Article 27 of the Constitution cover a part of that right. Most importantly, my lord, when a party has been sued in legal proceedings, he is clearly entitled to be notified through service of the allegations made against him. My lords, the other respondents were the Attorney General and the Iebc. That comes out clear, my lord, from pages 21 to 60 of our record.
Yes.
Looking at the law, my lord, it's quite clear that the Attorney General who was the second respondent, is entitled to represent the government under Article 156 of the Constitution of Kenya. Under Article 131(1)(a) of the Constitution, the President is the head of government, and they would be entitled to be represented by the Attorney General. However, my lords, His Excellency was sued in his private capacity in petition number 426. And the Attorney General indeed objected to this mode of enjoining the President in the paragraphs 1, 2, and 3 of his grounds of opposition.
Yes.
Yes. And we submit, my lords, that the Superior Court proceeded initially on the basis that the Attorney General represented the President.
Yes.
However, that issue arose, my lord, when it came to writing the judgment. And even though this was not framed as one of the issues for consideration by the court, they made a finding, a preliminary finding, that the President should have responded to the petition in person or through his legal representative. But surprisingly, my lord, their lordships did not ascertain whether the President had been served.
Yes.
And my lord, it is true that the President was never served with the proceedings, despite the fact that he was sued in his private capacity. My lords, I invite you to have a look at the record supplied by the court and presumably the filings by the respondent in this particular matter, and you'll find no evidence of service at all. Contrary to the express provisions of the Mutunga rules, legal notice number 117.
Yes.
Perhaps without tiring your lordship so much, allow me to refer to a few of the rules. In the definition section, my lord, it is said service means delivery of an order, summons, or other legal papers to the person required to respond to them.
Where are they in your record?
I beg your pardon?
The rules, where are they?
No, we didn't put them because they are legal notice,
Okay, sir.
my lady. We didn't enclose them, but they are legal notice number 117. So the position, my lord, is there has to be service on the person. And if you do it in any other form, there is a requirement that there must be a return of service in a particular form. You will find it, it's called Form B. My lords, in all the documents filed in this court, there is no return of service as required by the Mutunga rules.
Yes, we've recorded that.
Yes. Then if you allow me, my lords, I'll look at the effect of failure to serve. And what happens when the court nevertheless proceeds to make orders against a person who has not been served. Our rules are very clear, my lords. No one should be condemned without being heard. And indeed, their lordships did make a finding that, look, the president should have come here, should have responded through his own advocate. Failure to serve proceedings, my lord, is a serious omission in litigation. When the court, my lords, proceeded to make orders and declarations against His Excellency, it breached in particular his rights given by the Constitution under Article 50, fair trial, and also under Article 27, which gives him the right, like any other Kenyan,
Yes.
and indeed, my lord, there is in an affidavit, my lord, contained in our supplementary record of appeal, page 005. The petitioner, my lord, in paragraph 10 of that affidavit, avers that, notwithstanding that he was not personally served, the applicant elected to enter appearance in constitutional petitions number 282 of 2020 after judgment delivered on 13th May 2020, and is now participating in consequential proceeding, including the instant application that is tendered appeal, clearly implying that the applicant was indeed aware of the proceedings in the consolidated petition number E282 of 2020 and the fact that he was the respondent petition E46. My lord, having knowledge has nothing to do with it being served.
This is the affidavit of who?
This is the affidavit by the respondent, who was the petitioner in the High Court, Isaac Aluch. He admits, my lord, there was no service. There was no personal service. My lords, allow me just 2 minutes. So I pose the question, my lords, where somebody or a party has not been served, but the court has proceeded to make declaration and orders against that person. Are there any particular rights that have been breached? we have indicated breach of rights under Article 27 and Article 50. But more importantly, my lords, what is the effect of such orders? The breach of fundamental rights in relation to litigation are so serious, the courts have consistently found that such an order or a declaration is a nullity. One of the best decisions in this matter is a decision of this court, my lord. It is contained in pages 6 to 12 of the appellant supplementary use of authorities, and is the case of Raila against Indimuri. It's a 1989 decision.
Yes.
It came to the clear conclusion, my lord, that without service, whatever results from those proceedings constitute a nullity. And there is another authority, my lord, which we have relied on quite a bit in the courts. Is the case of Onyango Olo against the Attorney General. It's a 1986 decision. And I like that part of the judgment, my lord, which says, you cannot say, even if you came, you are not in a position, perhaps, to convince us not to give the orders that we gave. It doesn't matter. It doesn't matter whether there was evidence or no evidence in relation to the cause of action against the person who has not been served. It is a nullity. So my prayer today, my lords, on behalf of His Excellency the President, is that he was not served with the process in petition number 426. And yet the court proceeded to make certain orders and declarations against him. I pray that this honorable court, that your lordships do set aside all the orders and all the declarations adverse to His Excellency the President.
Mr. Gatonye, Mr.
Yes.
Uhuru,
Yes.
You are asking that this court declare null and void and set aside the declarations against the president, in his personal capacity.
Yes. He had been sued in his personal capacity.
Is there a place where he was sued as I saw the presidency enjoined in one of the petitions? That's different. You talk about in his personal capacity.
The point would be, my lord, perhaps it's a bit wider than this, taking into account that when the trial was rising from petition number 426, comprehending 426, should be declared a nullity.
Thank you.
All right. You're done, Senior Counsel?
Sorry, we have my good friends who are going to...
Yeah, that's what I was asking, whether you're done on your part on that thematic area before we move to another one.
My lord, I am.
Thank you.
And thank you so much for your patient hearing.
Thank you.
My lords, I'll straight away deal with the issue of presidential immunity, which forms one of the grounds of our appeal. My name is Mohamed Nyauga, appearing for the appellant in this matter. My Lord, the petition in the High Court that made allegations against the appellant is to be found at page 20 to 27 of our record of appeal. That petition, my lords, frames issues, and one of the issues that that petition framed forms the basis of the declarations against which we filed this appeal. And the declaration is to be found at page 528. It is important to note, my lords, that the court framed issues at page 357 to 359 of the record of appeal, but the issue forming the basis of the declaration was not one of the framed issues. This issue then was subsequently framed as a preliminary issue in the middle of the judgment at page 429 of the record.
Might you have the paragraphs of the judgment?
Yes.
Okay.
Sorry, my lord. Is paragraph 532 where that particular issue was framed as a preliminary issue in the middle of the judgment.
Yes.
My lords, the judges issued a declaration that the president could be held personally liable for functions or performing functions of his office. And this is what we are aggrieved about. In holding so, yes, my lord?
Mr. Nyaoga, please, I think it's important that there's a distinction there.
Yes.
So we need to, did they say he could be held personally liable for performing his functions, or did they instead say he could be held personally liable for performing functions that are outside what the Constitution gives them? I think that's a very important distinction. If you could address it, please.
My lord, perhaps if you go to the declaration,
yes,
maybe I can read it. A declaration is hereby made that civil proceedings can be instituted against the president or a person performing the functions of the office of the president during their tenure of office in respect of anything done or not done contrary to the Constitution.
Yes, that is so not for what is done within their powers under the Constitution, but outside.
Personally. That's correct, my lord.
Okay, carry on.
Yes.
That is page.
It is page 528 of the record. Page 528 of the record.
Maybe you can start with the question that they posed at paragraph 532.
532, my lord.
The one you referred us to.
Yes, I go there straight, my lord. The other question that deserves attention and which we thought we should determine as a preliminary issue is whether Mr. Uhuru Muigai Kenyatta, remember they're referring to him in name, can be sued in his personal capacity and not as the President of the Republic of Kenya. This is because he's named in his personal capacity as the first respondent. A straight answer to this question is found in Article 143(2) of the Constitution, and I'll be touching on this article.
Okay.
Yep. My lord, in the court so holding, it rejected the Attorney General's submission that the nature of proceedings that can be brought against the President is limited to judicial review and only through the office of the Attorney General. The rationale for that decision is found at page 437. And the rationale, my lord, if I can paraphrase it, is that the president, in his position as president, can engage in acts that can lead to a dangerous path for the country, and therefore a party can go to court to restrain the threatened acts. I'm paraphrasing it. And the court actually held or found that it depends on the nature of the violation, but also the circumstances of each particular case. A very shifty criteria, if you wish, my lords. And yet, as I'm going to point out, there is a framework within the Constitution for dealing with such situations, my lord. And I'll be referring to that very, very, very shortly. My lord, this holding was without constitutional basis. And if you look at the grievances in the petition, though the petitioner avers that they have sued the appellant in his personal capacity, the grievances refer to official acts of the appellant. For example, the petitioner complains about the Gazette notice to be found at pages 23 to 27 of the Record of Appeal. Those are official acts. But also, if you look at the findings by the judges at page 494, a finding that is a contradiction in terms, this is what they say, if you allow me.
So kindly, can you refer to the paragraphs? It's easier for us.
Yes, sorry. The paragraph is if you allow, the paragraph, the findings. The findings. I refer to that in a minute. My lord, the finding is at paragraph 494, page 411 of our Record of Appeal. That finding constitutes a contradiction in terms. It is inconsistent.
Sorry, which paragraph?
Paragraph 494 of the judgment. 494, my lord, you found it?
Yes, proceed.
Thank you. Let me read it, because it's important. It has been argued that the president was acting in his personal capacity and not as the CEO of the Republic of Kenya. The argument, however, is betrayed by the very fact that the Bbi Steering Committee was established via a Gazette notice, an official publication of the government of the Republic of Kenya. And its report was addressed to the Excellency, the President of the Republic of Kenya, and the Commander-in-Chief of the Defense Forces. Now, my lord, this cannot support that declaration. It is inconsistent with the declaration. They declare here that the acts were official acts. And if they are official acts, the AG was the right party to represent him and not to enjoin him at the personal capacity.
Do you agree with that finding at paragraph 494?
Yes.
That in establishing the Bbi Steering Committee, your client did that in his official capacity as President and Commander-in-Chief of the Defense Forces?
My lord, the Gazette notice speaks for itself.
I'm asking whether you agree with this finding.
No, my lord, the submissions have been made, and my learned friend, Mr. Karago, is going to address that particular issue. But what I'm addressing here now is that the allegations, the petition, were personal. But rather, he sued in his personal capacity. But the allegations went to his official capacity. The issue you raise, my lord, it will be addressed by my learned friend, Mr. Kiragu. My lord, Article 143.2 confers absolute immunity to the president. Article 143.2 of the Constitution confers on the president absolute immunity. Even a plain reading of that article speaks to that, my lord. And therefore, in making that declaration, the court erred first in the interpretation and application of that particular article. That article is clear and express that no civil proceedings can be commenced against the president during his tenure in office.
And does it end there?
Mr. Counsel, can you clarify Article 143.2 about the absolute immunity?
Yes, my lord.
How do you read it? Just read it.
143. Civil proceedings may not be instituted in any court against the president or the person performing the functions of the office or during their tenure of office in respect of anything done or not done in the exercise of their powers under this Constitution.
So what's your understanding or construction of the last sentence in respect of anything done or not done in the exercise of their powers under this Constitution?
My lord,
does that speak to absolute?
Yes, it talks about omissions or commissions.
Yeah, but I'm asking,
yes,
to the extent that it talks of anything done in the exercise of their powers under the Constitution.
Correct.
What happens if something is done not in exercise of the constitutional power?
My lord, judiciary.
If, for example,
yes,
just as an example,
yes,
the president's neighbor has a difference with him on a land issue, can he sue the president on that land matter?
my lord,
what would be your answer?
you cannot sue him. The immunity is absolute because the president may have exercised his powers as president. And I cannot actually try and contemplate the reasons why he took that action. I don't want to be in some sort of academic exercise as to, but what we are saying, my lord, is that the acts complained of were acts performed under the Constitution. That is the subject issue that we are dealing with.
Let me ask you,
before you.
Mr. Nyaoga.
Yes.
Supposing I were the president of the republic, and in my home in Kesagon, in Trans Nzoia, I keep dogs. My dogs escape, and they are vicious dogs. They go and bite my neighbor's child. What is presidential about my dog biting so that I will be protected from suit?
My lord, those are personal acts.
Exactly.
Okay, those are personal acts, and it is very yes.
Are they protected by Article 143.2?
My lord, if that particular neighbor is asserting a constitutional right against the president, and the president then asserts his constitutional right of immunity, then
would he not sue me as Patrick Omwenga Kiage of
but during your tenure, no, my lord.
Okay.
You can assert immunity.
Okay.
Yeah.
But before I leave that point, I want to come back to you.
Yes.
Is there a difference between Article 143.1, which clothes the president, which immunizes the president from criminal proceedings. Look at the text of the Constitution. It clothed the president with absolute immunity from criminal prosecutions, at least for that point.
Yes,
is there a difference between 143.1 and 143.2?
My Lord, the 143.1 immunizes the president against criminal proceedings. 2, civil proceedings.
There are the words that the president pointed to you, the last words in Article 143.2. They are not there in Article 143.1.
No, they are not.
And yet the meaning from where you stand, sir, is exactly the same for the two?
It's the same.
Okay, thank you.
So your submission is that, Senior Counsel, is that 143.1 and 143.2 should be construed the same?
Because, my Lord,
the nature of the immunity.
Yes. My Lord, these issues have received judicial interpretation. And I'm going to point out the particular decisions that have dealt with these issues.
Okay, very well. You may proceed.
Yeah, thank you. My Lord, it is our submission that by the judges so holding and issuing that declaration, they effectively repealed Article 143 of the Constitution and they rendered it of no consequence. The purpose of the immunity for the president was negated and defeated. But, my lords, there is a mechanism under the Constitution for addressing presidential impropriety. And that is to be found under Article 145, which actually follows Article 143 of the Constitution. And what does it provide, my lord? It provides that it is a quasi-political and and legal process. A member of the National Assembly, supported by at least a third of the members, may move a motion for the impeachment of the president on the ground of gross violation of provisions of the Constitution or any other law. Where there are serious reasons for believing that the president has committed a crime under national or international law for gross misconduct. And therefore, my lords, the court put the cart before the horse. Because once Parliament invokes this particular provision, the party aggrieved, if it's the president, then he can go to court. He can challenge that in court. But now here we are confronted with a declaration. If tomorrow Parliament were to commence proceedings, which forum is the appellant left? So the plain meaning of that article, as read together with Article 143 and 145, provides as follows: that the president is protected from legal proceedings during his tenure if he's exercising his powers under the Constitution, and where there's a basis that the president has misconducted himself, either under the Constitution, my lord, or any other law. And the question you pose, my lord, to me about a neighbor, and if the president misconducts himself in that regard and breaches any other law, then a party can invoke this mechanism, my lord.
My neighbor can move to have the president impeached because my dog beat the neighbor?
My lord, haven't you seen the parliamentary committees, for example, on justice, dealing with such issues before they go to the main house?
Okay.
My lord, let me wind up because my time is running. But the protection of state officers does not just cover the president. It covers yourselves. It covers magistrates. and it covers judges. The president is a state officer under Article 260 of the Constitution. In fact, if a party is aggrieved with a judgment of the court, he cannot go to court. And my lord, in your decision where you profoundly laid the law, this is the case of Gikonyo. And remember, my lords, that under Article 160 of the Constitution, which covers judicial officers, 160, a member of the judiciary is not liable in actions or suit in respect of anything done or omitted to be done in good faith in the lawful performance of judicial function. My lord, remember that we don't have such a restriction in the article touching on presidential immunity. My lord, you profoundly stated in the decision of Bellevue Limited versus Gikonyo, and this is number 3 in our case digest, and I can read the relevant section very quickly. I have no difficulty whatsoever in holding that judicial officers are under Article 160 immunized, and I must say the president is also immunized in such a manner, from any actions or suit or on account of the performance of a judicial function. I do not apprehend the words good faith and lawful in the sub-article a qualification or limitation of the immunity, for the rather obvious reason that as long as a judge is acting in a judicial capacity and exercising usual jurisdiction, there is a common-sensical presumption that he is acting lawfully and in good faith. There exists an implied covenant of good faith and binding the judges. My lord, what is the same?
The only issue, senior counsel,
yes,
you're not clarifying to us is that you see Mr. Olochier alleged that the appellant in this case did certain acts in his personal capacity. That is an allegation. There is a Gazette notice which shows perhaps otherwise, or there's a combination of both. But you do not seem to be distinguishing what is done in an official capacity, even in the judgment that you have referred us to, the Bellevue case, where some individuals purported to sue a judge because of a decision that he had made.
Yes.
And therefore, I think here in the case, or you have cited that to us, the emphasis was something done in his judicial capacity, judicial function.
Right.
And that is why Article 143(2) talks of in the exercise of their power under the Constitution as the President of Kenya, as opposed to, for example, a commercial transaction that I enter into as a judge. In my personal capacity, myself versus my neighbor, in a land matter, in a commercial, in a contractual arrangement. That is the distinction that we would like you to draw to us, and we see whether this immunity is absolute or not.
Okay, my lords. First, my learned friend, Mr. Karagu, is going to address the issue of the president's right to act in the manner that he acted. But on my part, my lord, I pointed out the Gazette notice. It's an official government Gazette notice.
That one we agree. We agree.
So that is the capacity in which I'm submitting. But on the other acts under the Constitution that the president performed, my learned friend, Mr. Karagu, is going to address that.
Okay.
Yeah.
Okay.
My lord, this position was confirmed or affirmed by the Supreme Court in the same decision. My Lord, I think I've made that point already, so let me move on, my Lord. The issue of presidential immunity is not peculiar to Kenya. It's not unique to Kenya, and it is found in many other jurisdictions. And there are various constitutions that hold that the president is immune from criminal or civil proceedings while in office. Let me point out the decision of United States of America in Mississippi versus Johnson. Also the case of Nixon versus Fitzgerald. And this particular decision deals with absolute immunity, and this is what it says, that the president's absolute immunity is a functionally mandated incident of his unique office rooted in the constitutional tradition of the separation of powers and supported by the nation's history. The Supreme Court further stated that because of the singular importance of the presidential duties, the diversion of his energies by concern with private lawsuits would effectively cripple the functioning of his office. Same position in Botswana, in section 4.1 of the Constitution, which provides almost in similar terms. The only difference is that it points out that anything done or omitted to be done in his or her private capacity.
That, Mr. Nyaoga.
Yes, my Lord.
The case from Botswana.
Yes.
The Botswana Constitution at section 41(1).
Yes.
Is it your position that that little addition there, which is not in ours, which says, is immune in both his official as well as private capacity? The Botswanans are saying their president is immune also in private capacity. Do we have a similar provision in our constitution?
We don't have a similar provision, but the principle is that it provides immunity to the president.
Okay. Absolute?
There's a difference in constitutions.
Is Botswana absolute, would you say?
Yes, it is.
And if ours doesn't have private, would you still say ours also absolute?
We have our own history, my Lord.
Okay, sure.
Pardon me for
yes,
elaborating this point.
Yes.
In your view, the words at the end of 142.2
yes, my Lord.
That talk about in respect of anything done.
The proceedings, so the last words, my Lord?
Yes.
Respect of anything done or not done in the exercise of the powers under this Constitution. My Lord, this touches on any act by the President not done or done under the Constitution. But remember, my Lord, that the Constitution is the supreme law of the land. And remember that it is pointed out that if the President offends any other law, so that if in any other act that he performs, he offends any other law, he can be subject to the mechanism provided for under the Constitution. Thank you, Lord. In Nigeria, And Section 308(1) of the Constitution also provides immunity for the President. But in the case of Katiba Institute, my Lord, which is in our digest, it is number 7 in our digest. Any party, my Lord.
Sorry, and this was by which court?
This is judicial review.
No, this was a High Court judicial review matter.
Yes, my Lord. And I can paraphrase it, that if there's any party that is aggrieved by any act of the first respondent, the available remedy is judicial review or constitutional declarations, my Lord. But they sue the Attorney General, who will then appear for the President in the proceedings. So, my Lord, to conclude, if that position were to be upheld, it will lead to a multiplicity of proceedings against the President. It will open a door for civil suits against the appellant. And, my Lord, there is functional necessity. The President will be distracted from performing his activities under his mandate. It will interfere with his duties, and it will be disabled from executing his duties. And therefore, my Lord, it is my prayer, it's our prayer, that that declaration be set aside.
Senior Counsel, are you planning to give Mr. Kiragu Kimani, Senior Counsel, any time?
I'm now yielding to him. Thank you. Thank you.
Thank you. May it please the court. I'm going to deal with the twin issues of whether the High Court erred in determining that the appellant had violated Article 73, Sub-Article 1A of the Constitution. And I want to make 5 points. But before I get into those 5 points, I want to direct you to where these findings are made. You will find them at paragraphs 485 to 499, and 582 to 588 of the judgment, and that is at pages 407 to 413, and 451 to 455 of the Record of Appeal. That's volume 2. That's with regard to the finding that the President had no right or is not entitled to initiate an amendment of the Constitution other than through a parliamentary initiative. The second basis on which it was held that the appellant had violated the Constitution is to be found at paragraph 557 on page 442 of the Record of Appeal. And this was a finding that there was no evidence that the appellant followed the Constitution in setting up the BBI steering committee. You may also want to look at paragraph 588. Very quickly, my lords, your ladyships, first thing before I even look at the 5 points I want to make is that a violation is a serious transgression. I will not address whether you can find that a person has made a serious transgression, whether any court can make such a determination without hearing the person, because that's been addressed not just by Mr. Waweru Gatonye, but by others. The first of the 5 points I want to make is this. We take great pride in our democracy. And one of the fundamentals of any democracy is that if you want to prohibit something, generally speaking, you do it expressly. Putting it differently, if it's not expressly prohibited, it is permitted. No one has pointed you to any provision in the Constitution that bars the President from initiating an amendment to the Constitution through the popular initiative. Likewise, nobody has directed you, not the respondents, not the judges of the court below, to any provision in the Constitution, or indeed any other law, that restricts the President to a parliamentary initiative. In a word, there is no absolute prohibition, there is no prohibition, and the judges were wrong to determine that the President could not. I'm not suggesting for one moment that he was behind the initiative. That's been addressed by others. I'm simply saying that they reached an erroneous conclusion and then went on to say that he was in violation of the Constitution. The second point I want to make is that the decision of the lower court, looked at as a whole, determines that the President is expected to be apolitical. In my humble submission, that's fundamentally wrong. When you consider three things: he is a citizen, like any other citizen. He has rights under Article 38. Secondly, he is a leader of a political party. He can take any position he wishes with regard to the Constitution. And thirdly, he can be involved in the amendment process. The third point I wish to make is that Article 38, which the President, like any other citizen, is entitled to benefit of, to benefit from its protection, is part of the Bill of Rights, and pursuant to Article 24, cannot be limited except by law. I come back to my first point. You have not been directed to any law that limits his right to participate in the amendment process. The fourth point, and this is where I will take a moment to address the questions posed by my Lord the President, Mr. Justice Musinga, and my Lord Mr. Justice Kiage, is that the appellant's actions must be appreciated, the context. Fortunately, and I'm indebted to my Lord Mr. Justice Kiage to directing our minds to paragraph 494. The question of the capacity in which the appellant was acting is settled by that paragraph. The judges roundly rejected any suggestion that he was acting in his personal capacity. No one, not the respondents, not anybody, has filed a cross appeal pursuant to Rule 93. That issue is settled. So in many ways, I think it is moot whether he was acting in his official capacity or not. That's settled. That's not before you for determination. But I think my Lord Mr. Justice Kiage is entitled to a straight answer. If it's a question of a dog, in my view, so. But with respect, that's not where we are at today. It is clear that we are talking about the President acting in his official capacity, and I come back to the context, which is that there was a finding, and I'll return to this case, the Third Way Alliance case, which you will find at pages 95 to 138 of our digest, by Mr. Justice Mativo, that in the process the President was acting in discharge of his functions under Article 131, Subarticle 2, that decision remains unchallenged. Put differently, the appellant was acting under the authority given to him by Article 131, Sub-Article 2C of the Constitution. But in that, he was fortified by a decision of the High Court. And that cannot be assailed at this point in time. And I'd like to borrow the words of my learned friend Bbi. What would be the result of allowing people to pick and choose decisions? You're going to have judicial anarchy, I think those are the words he used. The fifth point I wish to make with regard to this particular limb of the argument is that the High Court unfortunately adopted a disjunctive approach in interpreting the Constitution.
Senior counsel, what do we do with you when the time shows?
I will ask that you give me the 5 to 7 minutes that were taken up by the questions by the bench.
Okay. Can we give you a maximum of 5?
I appreciate that, my lord. I will leave with that.
Okay.
So they did not follow advisory opinion number 2 of the Supreme Court, which is authority number 11 in our bundle. You will find it at pages 215 to 274. They failed to look at Articles 119, which says any citizen can move parliament and can go to parliament. They failed to consider Article 38, which protects the appellant, whether he be president or not. Let me now look at the effect of the decision in the Third Way Alliance, and I want to make very quickly again 5 points. The paragraphs you wish to, I'd invite you to look at when you retire to consider the matter is paragraph 531 on page 427 of the Record of Appeal, Volume 2. I also want you to look at paragraph 525 on page 426 of the Record of Appeal. The first point I want to make here is that it is not in dispute that the 20th and the 21st respondents in this appeal had filed another case. That's the Third Way Alliance case, which you find at pages 95 to 138.
Yes.
And in that case, they attacked the BBI task force, which was the precursor to the steering committee. They actually filed the task forces. It was before the judge, and the report contains pretty much what went into the bill that the steering committee prepared. The doctrine of res judicata, or the principle of res judicata, requires a party to plead their entire case. They cannot litigate in installments. They cannot come to the court a second time and say, we want to have another bite. I invite you to look at the supplementary affidavit filed by the Third Way Alliance. And I invite you also to consider the orders they sought before Mr. Justice Mativo. My lords, your leadership, the High Court judges attempted to get round that decision by saying that the Attorney General had only pleaded issue estoppel with respect. That's not a sufficient answer. It was incumbent upon them to ask if Third Way Alliance was before the High Court one time. Were they barred by the doctrine of res judicata from raising the same question in a subsequent action? They filed a subsequent petition. In my humble view, they should have barred them. In the result, What we are asking the court is to determine that it does not matter that the appellant is the President of the Republic of Kenya. Like every other citizen, he is entitled to equal protection of the law. He was entitled to be invited to the party by being served. He was entitled to be given an opportunity to address the court on the questions that were before the court. Indeed, the only person who placed him or took him to court, Isaac Aluochier, admits at paragraph 3.16 at page 20 of his submissions that the first order of business should have been for the High Court to ensure the President was served. He was not. For these reasons and for those set out in our submissions, we'd urge you to allow the appeal. Unless there are any questions, I propose to take my seat.
I don't see any question. Thank you very much. All right. We now move to the respondents who are supporting the appeal. We have, is it Mr. Kuyoni, 7th respondent? Mr. Kuyoni, can you do with 20 minutes?
My Lord, I believe I can do my submissions within 20 minutes.
Okay, please proceed.
My Lords, my name is Kuyoni Josephat, my Lords, and I appear for the 7 respondents, the National Assembly. To begin with, my Lord, it is very difficult for me, my Lord, to now appear before you when senior counsels have gone before me, because, my lords and ladies, they have actually submitted on almost everything that I had intended to submit on.
That is very good. If you find that there is nothing useful to add, you can borrow that line.
So, my Lord, if in case you find me, my Lord, repeating submissions which have already been submitted on, my Lord, I will kindly ask the court to understand.
Yes.
And my Lord, I will start with introducing the documents that we have filed on behalf of the National Assembly. And my Lord, on behalf of the 7 respondents, we have filed submissions to the appeal, consolidated appeal. The submissions, my Lord, are dated 23rd of June 2021.
Yes.
We have also filed a replying affidavit, my Lord, sworn by Mr. Michael Selai, the Clerk of the National Assembly.
Yes.
In response to the JLAC report, my Lord, introduced by a respondent called Mr. Miruru. My Lord, before I proceed, my Lord, I have a small correction to make. The affidavit, my Lord, is erroneously dated as sworn on 28th of June 2020.
The one of CLI?
Yes, my Lord. Instead of 28th of June 2021. It's a minor correction, my Lord. I will kindly request the court to allow that amendment.
Okay.
My Lord, for the record, my Lord, the 7 respondents, my Lord, supports all the appeals that have been filed before this court. And we wish, my Lord, to associate ourselves with the submissions that have already been made by my learned seniors on behalf of the appellants. However, my Lord, I will just make brief comments, my Lord, on a few subjects, mostly, my Lord, stating the position that the 7 respondents is taking on the issues, my Lord. And the first issue is on the doctrine of the basic structure, applicability of the basic structure doctrine in Kenya, my Lord. My Lord, the Superior Court, my Lord, at page 473, paragraphs 473 and 474 of the impugned judgment, held, my Lord, that the doctrine of basic structure is applicable in Kenya. And in arriving to that conclusion, my Lord, the court relied heavily, my Lord, on the history of the constitution-making process in Kenya. My Lord, the same history, my Lord, has informed the drafters, my Lord, to enact Chapter 16 of the Constitution. Chapter 16, my Lord, has been ably submitted on, has made it very rigid, my lords and ladies, to basically make hyper amendments to the Constitution. So, my Lord, it's not correct for the court to state that the basic structure doctrine is applicable for purposes, my Lord, of protecting against the destruction of the Constitution by political and other allies, as alluded by the court at paragraph 474. My Lord, in fact, the opposite is true. Chapter 16, my lords and ladies, provides, my Lord, sufficient safety valves for the amendments of the Constitution, my Lord. And my Lord, history can bear me witness, my Lord. There has been a number of attempts, my Lord and ladies, to amend the Constitution. And to illustrate, my Lord, I'll just give a few examples, my Lord. And the first example, my Lord, was an attempt to amend the Constitution to move the date of election from August to December. My lords and ladies, that intended amendment did not go through because it did not garner the 2/3 required majority in the houses. Similarly, my Lord, we had two other attempts, my Lord, an attempt by Third Way Alliance, which did not go past the counties.
Actually, we were told there were 22, so you do not need to belabor that.
Yes, my Lord.
22 unsuccessful.
Thank you, my Lord, for that guidance, my Lord. I just wanted to point out, my Lord, that it's not possible under the current Constitution to make hyper amendments to the Constitution. And therefore, my Lord... Yes, my Lord.
How many, in terms of numerosity of instances, there may be there clearly is a basis for that. But this particular attempt, how many amendments are contemplated?
My Lord, it's a number, my Lord, under the bill. My Lord, I have not gone through the bill to, not that I have not gone through, I have not counted the number on the bill.
Is it true that there are 74 at one go?
It may be true, my Lord.
Okay.
It may be true. So, my Lord, what we are saying, my Lord, and what we are submitting on, it's not possible, my Lord, to make hyper amendments to the Constitution, as has been alluded by the court. My Lord, in that case, if the basic structure doctrine was intended to serve that purpose, then, my Lord, it should not be applicable because that situation does not exist at the moment. My Lord, I want to quote a famous phrase, my Lord, from the trial, or the famous trial of O.J. Simpson, my Lord, where, my Lord, the trial, the defense attorney, Johnny Kochman, my Lord, the defense lawyer, approached the jury, my Lord, and told them, my Lord, if it does not fit, then you must acquit. This is the same situation here, my Lord. If the Constitution prevents amendments, my Lord, hyper amendments, then the doctrine should not apply. Second issue, my Lord, on the basic structure doctrine, the Honorable Attorney General, my Lord, had referred the Honorable Court to decisions in our neighboring countries, my Lord, Tanzania and Uganda, where, my Lord, the doctrine was found not to be applicable. My Lord, I won't say that much on that, my Lord. I just wish, my Lord, to plead with the court that in line, my Lord, with Article 126, my Lord, of the Treaty for the Establishment of the East African Community on Judicial Affairs, which encourages standardization of judgments of the courts in the community, my Lord, that in the spirit of the East African Community, you find, my Lord, that the doctrine is not applicable. My Lord, we had also intended to submit on the popular initiative remit, my Lord, but it has been substantially covered by my learned seniors. And therefore, my Lord, I adopt the submissions made by my learned senior in that respect.
Yes.
The second issue is the admission of the amici before the Superior Court. My Lord, Senior Counsel Karori, my Lord, had ably submitted that, that a Superior Court had admitted amici, my Lord, that were clearly partisan or had taken a position similar to that of the petitioners before the Superior Court. And my Lord, just to emphasize on that, my Lord, this amici participated in interlocutory applications without invitation of the court, my Lord, contrary, my Lord, to the principle set out in the Mutembei case. My Lord, the same amici, my Lord, are before you today as respondents. We'll be urging you, my Lord, to disregard the submissions made by the amici. The third issue, my Lord, is on the justiciability.
Just a moment.
Yes, my lady.
Yeah, you have asked us to disregard their submissions just because they are titles as respondents.
My Lord, before the trial court, my Lord, they had appeared as amici. They had taken a position. We are submitting, my Lord, that the admission, my Lord, did not comply with the principle set by this honorable court. That is my, my submission, my lady.
Did you raise an objection?
We did, my lady.
All right.
Yes, my lady, the third issue, my lady and lords, we intend to make a brief comment on is the justiciability doctrine. My Lord, by the time the petition number 282, which was the leading file, was filed before the trial court, the action had not crystallized. There was no dispute. The bill had not even been published. It had not gone through the consideration processes, my Lord, by the counties and the National Assembly. My Lord, we are left with a question, my Lord. What would have happened had that bill died in the county assemblies or even parliament? Would have been left, my Lord, with an academic petition. So, my Lord, we are saying the judgment, my Lord, rendered by the Superior Court is an advisory opinion that is not based, my Lord, on factual situations. And lastly, my Lord, I would like to make a brief comment on the JLAC report. This issue, my Lord, has been ably submitted by Senior Counsel Otienda Amolo. I'm just supplementing, my Lord, what has already been said. I adopt in totality the submissions that he has already made before the court. My Lord, which provide, my Lord, committal of bills to the relevant House committees. That standing order, my Lord, stipulates that committee reports are tabled before the House for purposes of informing debate. They are not binding. And ultimately, my lords and ladies, it is the House that has the final say on the reports. In this particular report, my lords and ladies, the House did not adopt it. So as it stands, the committee report and the recommendations contained therein remain recommendations which are not adopted by the House. And therefore, our submission is that they are of no value to this honorable court. For those few remarks, my Lord, we urge you, my Lord, to allow the appeals as prayed by the appellants. Thank you, my Lord and Lady.
Thank you.
Thank
you very much. Sorry.
Just wait. Are you saying that there is no way of resuscitating them? They are mere recommendations, and that is the end of the matter?
My Lord, unless the House adopts, votes to adopt the recommendations in the committee reports, they remain mere recommendations.
All right. Thank you very much.
Thank you, my Lord and Lady.
Thank you. Who is representing the Senate? Is it Mr. Wambulwa? Mr. Wambulwa, you represent the 8th respondent. Is that so?
That's correct, my Lord.
Okay, just state your name for purpose of the record.
My Lord, my name is Job Wambulwa. I represent the 8th respondent, the Senate, and the Speaker of the Senate. And my Lord, I insist it's Job Wambulwa. I've seen some respondents indicating my name as John, others as Joseph.
Oh, it's Job.
Job Wambulwa.
Can we give you 10 minutes, Mr. Wambulwa?
My Lord, 10-15 minutes will be enough.
Okay. Okay.
My Lord, on behalf of the 8th respondent, the Speaker of the Senate and the Senate, we associate ourselves fully with the submissions made by learned seniors before us, and actually they have exhausted most of the issues. Therefore, we'll just be taking our position in every issue that we were to submit on. And before that, my Lord, allow me to introduce the documents that we filed in these consultated appeals. We filed submissions and list and bundle of authorities dated 23rd June 2021. Secondly, my Lord and my ladies, we filed a replying affidavit sworn by Jeremiah Nyegenye, the clerk of the Senate, in response to the protection of the JLAC report and Hansards of the Senate by Third Way Alliance. So, my Lord, allow me to touch on a few issues and the position that the 8th respondent takes in these issues. First, my Lord, we find it's our position and our submission that the Superior Court erred in finding that the basic structure doctrine is applicable in Kenya, and for the following reasons, in summary. One, my Lord, and an issue which my colleague, Mr. Kuyona, has alluded to, is that the leading file, petition E282, that actually sought those prayers, my Lord, was filed way before the Constitution of Kenya Amendment Bill 2020 was even drafted. There was no controversy, there was no issue before the court.
That is number 282.
282, my Lord. And my Lord, just for the record, we raised an objection to that petition. The trial court informed us that we were, because the issues we were raising of justiciability and ripeness could only be canvassed at the hearing of that petition. And my Lord, in our submissions, which we filed, and just to refer the court, my lord, in the bundle, in the record of appeal, filed in the leading file herein, that is found my lord. My lord, our submissions and preliminary objection that we raised to that point, my lord, is found in from at pages 344 to 346. Submissions, pages 459 to 472. Grounds of opposition, 390 to 391. Therefore, my lord, we find that the court erred in not considering our position that that matter was not ripe for determination at that point, and the court was engaging in an academic exercise. Secondly, my lord, that this doctrine is not applicable in Kenya on the basis that first, it's not universally accepted. It has not been universally accepted. And even in jurisdictions where it has been accepted, it has been concerned more with limiting parliamentary power to amend the constitution. That is not the case with our constitution, my lord. And that has been demonstrated in the list, in the authorities that we've quoted in our submissions, my lord. Thirdly, my lord, on the same issue, even with the countries like in India where this doctrine has been applied, there we find that there exists fundamental textual and contextual differences in those countries as compared to Kenya. For instance, when you look at the Constitution of India, I think Article 368, it gives absolute power to Parliament to amend the Constitution. That is not true with our Constitution. And at the same time, for instance, in India, Parliament can amend the Constitution with a simple majority. The same cannot be said of our Constitution, where even through parliamentary initiative, that bill to amend the Constitution has to be supported by at least 2/3 majority in both houses. And more so, if that issue touches on the aspects or issues highlighted in 255(1), then it has still to go through the referendum. So it is our submission that the Constitution has self-made mechanisms which guards against misuse through amendments. My lord, on the issue of eternity clauses, it is our submission that people exercising their powers can amend any clause of the Constitution, provided the procedure provided for in the Constitution is followed. And we adopt the words of the court in Dr. Timothy Njoya and others for the Attorney General, which we've highlighted in our submissions, that indeed if the framers of the Constitution had intended limitations on power of amendment, they could have provided so. I think the court was quoting the case of Lang, that is a Singaporean case. And indeed, my lords and my lady, it is my submission that if indeed the framers of our Constitution intended to have aspects of our Constitution which we consider that cannot be amended at all, then the same could have been provided for in the text of the Constitution. The second issue that we have to take a position on, and we have submitted on the same, is the issue of popular initiative. And we humbly submit, my lord and my ladies, that the Superior Court misdirected itself in finding that a popular initiative is only made for Wanjiku. and that no government organ or the president can initiate a popular initiative. It's our humble submission that there is no preclusion for any person or body, be it public or private, to initiate or promote, constitutional amendment through popular initiative, provided procedure laid down under Article 257 has been adhered to. The only requirement under Article 257 that a promoter has to fulfill first is for you to convince others, get 1 million signatures. On the other issue of the sufficiency of the regulatory framework, it is our position, and we submit, that the Superior Court erred in finding that there was no legislation or legal framework to govern the collection, presentation, and verification of signatures or conduct of the referendum. We submit that the Constitution of Kenya, that the Election Act provides sufficient guidelines, be it for Iebc or Parliament, to carry out their processes in popular initiative, amending the Constitution through popular initiative. And we rely on the position of the court in Titus Alila that you've been referred to severally, where the court found that the Constitution already had a set up mechanisms or legislative framework for holding a referendum.
Thank you, Mr. Omulwa.
My Lord, the last comment, just on the JLAC report, just to comment.
Yes.
My Lord, I want to direct this court to the affidavit of Mr. Miruru Waweru, in which they produced the Hansard of the Senate of 28th April and 29th April. My Lord, that Hansard, they selectively chose the 2 days. They did not provide the Hansard of the 13th May, when the Senate actually also deliberated during third reading.
13th May.
13th of May. And actually, overwhelmingly passed the constitutional amendment.
Have you provided it?
We have in our affidavit, my Lord.
Okay, thank you very much. We will look at it. Your time is up. Thank you very much.
Thank you, my Lord. And I wish to state that you allow the appeals as prayed by the appellants. Thank you.
Thank you, Counsel. Who is next? Mr. Ndegwa. Are you here? Mr. Ndegwa. Is there anyone representing the 43rd respondent? The indication we had gotten is that 43rd respondent was also supporting the appeal.
May it please the court?
Yes, Counsel, introduce yourself.
Mboshe is my name.
Sorry?
Njoki Mboshe.
Njoki Moshe.
Mboshe, M-B-O-C-E.
Yes.
I am not representing the 43rd respondent.
Yes.
Mr. Ndegwa is my learned brother, and he has indicated that he's on his way.
So who are you representing?
I am representing the 45th respondent.
45th respondent.
Indeed.
Thank you. 10 minutes.
Oh, my Lord.
Yes, all the grounds have already been argued. So take your 10 minutes. If you need any more time beyond that, we will determine.
Most obliged. Thank you very much. And my ladies, my lords, as I've indicated, my name already, I represent the 45th respondent in this appeal.
Yes.
And my lord, my ladies, we support the appeal. And why is that so? My lord, our main association with the appeal is because the appeal is urging this honorable court to find that nobody can legally oust Wanjiko's right to self-determination. My lords, my ladies, And this is essentially anchored on challenging various provisions or various findings of this Honorable Court, particularly the findings, and these are set out at page 310 of the supplementary bundle by the Attorney General, particularly, my lords and my ladies, the provision or the finding that the basic structure doctrine does not apply with respect to Article 250, or will apply, sorry, my lords, my ladies, that it applies with respect to Article 255, Article 256, and Article 257. My lords, my ladies, we submit that the doctrine of basic structure does not find any place within the Constitution of Kenya, Article 255 and 256, and this is because, my lords, my ladies, when my lords and my ladies retire, you will find that the case of Njoya has been referred to, and the Honorable Trial Court indeed looked to it with respect to the issue of the basic structure. My lords, my ladies, that particular case was addressing the aspect of parliamentary initiative, because that is what Section 47 of the then Constitution was looking at. It is not that particular provision of the Constitution or of the previous Constitution, my lord, does not have a provision like we have in Article 257. Therefore, because now we have Article 255 and 257, they anchor the provision that Wanjiku has the sole sovereign responsibility and right to self-determination to determine, my lords and my ladies, which kind of constitution she wants. And we cannot, my lords and my ladies, as we will find at the preamble of the Constitution, Wanjiku has not donated. She has not given up. She has not given up that particular right. She continues to hold it for herself and her future generations. Therefore, she will not want to be bound by eternity provisions or provisions that seek to suggest that no amendments can be done to the Constitution. Wanjiku reserves that right. She is required and she's entitled to keep it, my lords and my ladies. And therefore, the finding on page 230 with respect to that particular argument and declaration 1, that the basic structure is applicable to 55 and 256 and 257, my lord, is erroneous, both in fact and in law. My lords, with respect, and also when you look at the case of Kesavananda, my lords and my ladies, that was applied extensively by the High Court with respect to this matter, my lord will see that that case cannot apply to Kenya. Why, my lords and my ladies? Again, because that particular consideration with respect to the basic structure doctrine was looking at parliamentary initiative, my lords and my ladies. And therefore, because our Constitution distinguishes